Okay, counsel in case number 2, go ahead and make your way. Today's second case is 23-30357. Keiland Construction v. Weeks Marine. Mr. LeMieux, whenever you get situated, step on up.
Good afternoon.
Good afternoon.
May it please the court, Christopher LeMieux on behalf of Keiland Construction. To address the court's question that we received, Keiland is a Louisiana limited liability company. Its sole member is Mr. Keith DeRusso, and Mr. DeRusso is a resident.
He's the one and only member?
Yes, Your Honor, one and only member.
And he's a citizen of?
Louisiana. Resident of Lake Charles.
Okay.
We're here today to discuss construction contracts. Specifically, my client was a subcontractor on a project where Weeks Marine was the general contractor. The subcontract between Weeks and Keiland was a lump sum agreement. What lump sum means is it's a fixed price. You're going to do a contract for $1, and the way that the lump sum contracts work is you bill for those on a percentage complete basis. So if you completed 15% of work in a month, you bill for 15%. If you completed 25% of work the next month, you bill for 25%. So it matches the percentage of work that you do. My client performed work from January 8th, 2020 through March 18th, 2020. Keiland submitted its first pay application on March 4th, 2020 for $252,674.92. On March the 18th at 9 o'clock in the evening, Weeks terminated my client for convenience. So the first issue on appeal is the impact of the termination for convenience. We submit that the contract is clear, that the contract is unambiguous, and that the work that Keiland performed prior to termination should be done on a percentage complete basis. We also submit, and it's throughout the various articles, that Weeks did not properly pay my client. The contract, and we're going to talk about this in a little bit, the contract, specifically Article 5, requires that Weeks pay my client within one of two periods. One, within 14 days of receipt of payment by the owner, or two, within 30 days of submission of the pay application. That's important because this is a breach of contract case. And what we have pled and what we have argued is that Weeks did not pay Keiland in accordance with the terms and conditions of the contract. It's important to note that when my client filed suit in May of 2020, my client had not received $1 for the work it had performed, not one. Despite the fact that the contract specifically stated that we are to be paid within 30 days. Despite the fact that Weeks had been paid by the owner. In the record, and we cited the deposition testimony, specifically state, I can tell you that we were paid for every bit of work done by Keiland because we got paid under a lump sum contract. So Weeks had a lump sum contract with the owner. Weeks had a lump sum contract with Keiland. Once Keiland's work was done on that monthly basis, Weeks did an analysis of what the percentage was, and they turned around and they billed the owner on a percentage complete basis for Keiland's work. The first time that my client received a payment under this contract was in January of 2021, 11 months later. Throughout the course of this litigation, either by judgment or receipt of payment, my client has collected $416,936.59. Now, ultimately, the district court held that Keiland was entitled to sums owed under the contract. Held we were owed $118,936.59. We're also going to talk about attorney's fees. They allowed Weeks attorney's fees. But the difference, we're still owed $41,000. That amount is still unpaid today. They have never paid the amount that the district court held was owed. They still haven't paid it. They're still in breach today. Ultimately,
regarding the demobilization cost, is it your position that Weeks owes you more than the $25,000 plus that it previously paid?
no, Your Honor. I'm asserting that the demobilization cost shouldn't have been an issue at the trial. The reason is this. In that January payment, Weeks paid $25,000 for demobilization costs. They paid it. When we look at their affirmative defenses, they didn't plead offset, they didn't plead credit, they didn't plead clawback that they are entitled to additional funds. They didn't plead any of that. When we took the corporate deposition of Weeks, we specifically asked them, are you seeking a clawback? Are you seeking a refund? And the answer was no. So they never pled it. The amendment to pleadings deadline is passed. We asked them in the corporate deposition, are you going to seek these costs back? And they say no. They are bound by that 30B6 deposition testimony. So when the first time it comes up in this case is when they file a motion for summary judgment on damages and say, look, the demobilization costs aren't owed. Well, we point out to them, you've already paid them, number one. You've acknowledged that costs are owed. That testimony is in the record. And then secondly, you testified under oath in a 30B6 deposition stating you were not seeking a clawback. You were not seeking a refund. So our position is it never should have been before the district court to begin with because it wasn't pled. And when they testify in their 30B6 deposition, they are bound by that deposition. Now, as it relates to the other damages, Your Honor is correct. The rest of the damages aren't on appeal per se, with the exception of the employee costs. The two findings relative to this judgment are the demobilization costs, which we just talked about, and the employee cost. How we got to the damages portion was through a bifurcated trial. We had a half-day trial relative to contract interpretation issue. Judge Payne ultimately found that the contract was ambiguous, and then he believed that Weeks' interpretation, converting the whole contract to cost plus, was correct. We do not believe that Judge Payne's decision was correct. When the contract is not clear, then the court can look to other evidence. First, we submit that it was clear. How is it clear? Well, Article 5 states in the contract that we shall be paid pursuant to those provisions. What it also states is that we're going to be paid that way through the duration of the contract.
Well, except the termination clause supersedes that. I mean, in other words, you've got Section 5, which I think delineates the different categories of lump sum payment. Presumably, 100% complete equals payment in full for each of those categories. But then Section 9 says Weeks can terminate for convenience at any time, and at that point, you're entitled to cost plus the 21% kicker.
At that point going forward, absolutely.
But it doesn't say that.
It says upon termination, and then it says the cost of finishing the work. So if we look at Article 9, what Mr. DeRosso said is, look, there are 4 things in Article 9 that you can do. You have to stop work, number 1. You have to cancel material supplies. You have to protect your work, and then you have to finish anything that is not the subject.
But the original lump sum total for Task X is no longer operative at that point because you're not going to get to that 100%. In other words, I mean, I'm just trying to follow how the district court's reading of the contract was somehow incorrect or unreasonable.
Well, it was unreasonable because if we look at custom and usage, which the district court was obligated to do, Weeks billed for our work on a percentage complete basis. They did. They got paid for our work on a percentage complete basis. Why is that important? It's important because in Louisiana, we have a statute, 9:2784. And what that statute states is that if you are a general contractor and you get paid by an owner, you have a statutory duty to pay the subcontractor in the same proportion to what you've gotten paid. So if the court believes that it's ambiguous and we go look at usage and custom, 9:2784 specifically states that we have to be paid in the same proportion to what they got paid. So they billed for our work on a percentage complete basis. They got paid for our work on a percentage complete basis. And then they turned around and did not pay us what they had been paid.
Where is the language in the contract that talks about percentage complete?
Article 5.
So it's the same language as in Article 5.
Yes, Your Honor.
How is that different than lump sum payment?
So lump sum and percentage complete are the same thing. So you start with a lump sum amount, which let's just say it's $1. And then the percentage complete is every month. You don't do all of that work.
So it's encompassed in the monthly invoicing and all that sort of thing?
Yes, Your Honor. Yes, Your Honor. And it's exactly how Weeks billed the owner. It's exactly how Weeks was paid to the owner. And I keep going back to 2784 because it's very clear in the statute, which was not considered by the district court. And that says that the general contractor has to pay the subcontractor in the same proportion to what it received payment. So what we have here is they've received payment and they want to turn around and then say, well, we're not going to pay you for that amount. And that was not considered by the district court. Secondly,
where is that cited in the statute? Is it, the contract, I'm sorry, does the contract reference Louisiana law?
It doesn't, and in fact, it references another state's choice of law, and there was a dispute early on, and the district court held under revised statute 9:2779, if you are doing a construction project in Louisiana with a Louisiana contractor, then Louisiana law has to apply. And so ultimately, the district court held, and that's not on appeal, that Louisiana law applies to this contract under revised statute 9:2779. Beyond the contract interpretation, Your Honor, if we get to the issue of prevailing party, the district court found that Weeks prevailed on the contract interpretation issue. The district court awarded my client damages for the work that it did, but ultimately on that contract interpretation issue held that Weeks was the prevailing party. Now, we have cited to this court over 100 years of cases that say you can't do that. And specifically, we'll start off with this, the Fifth Circuit's holding in Shaw, 395 Fed 3rd 533. Our ultimate eerie guess requires we employ the appropriate Louisiana methodology to decide this issue the way that we believe the Supreme Court of Louisiana would decide it. So let's look at the Louisiana Supreme Court, and we've cited this. The first case that we cited to Your Honors is the Silverman versus Caddo, way back in 1911. And this all comes through to Stewart versus Shaw. And the issue in Silverman was that the plaintiff did not pay for services performed, but was seeking to recover damages under the contract. The Supreme Court held when a buyer of lumber failed to pay for it as provided by the contract, and the seller stopped delivering it after endeavoring in vain to collect the overdue payments, the buyer could not recover damages for the seller's refusal to further perform, since under Civil Code Article 1915, a party cannot claim damages for the non-performance of a contract, as to which he himself is in default. So 1911, first time the Supreme Court says, look, if you haven't paid for something under the contract, you now can't claim damages. Louisiana Supreme Court in 1912 says the same exact thing. To recover damages, the plaintiff must begin by showing that he has complied with the terms of the contract. In Murphy, There was a suit to recover damages for an alleged breach to deliver 10,000 barrels of oil, and it appeared that the plaintiff refused to pay the defendant for a part of the oil delivered under the contract. So they weren't entitled to damages because they didn't pay all the sums due. The most recent case that we've cited is Stewart versus Nash, which is 2023 from the Louisiana Supreme Court. Stewart, plaintiff filed suit against defendant because the defendant allegedly breached a non-compete. The trial court held defendant in a bifurcated trial. Yes, you breached the non-compete. However, when they got to the damage phase, the court did not award the plaintiff any damages. Because the court did not award plaintiff damages, they said that the defendant was the prevailing party. The Supreme Court comes back and cites the cases that I just cited to this court, also cites others that says the trial court did not err in rejecting a claim for attorney's fees and interest made by a construction company that breached the contract. They breached the contract. To this day, they have not paid all sums due and owing under this. Under the law going back to 1911, they cannot be the prevailing party if they, in fact, are in breach of the contract, which the $41,000 to this day is in breach. The last issue I'll discuss extremely briefly revolves around the employee cost. We submit quite simply that the employee cost, the court should not have ruled on it. We've cited to this court the standard for summary judgment is a genuine issue of material fact. We provided an affidavit, we provided sworn testimony, we provided our bid, we provided a rate sheet, and we provided email correspondence that all suggest that the project manager, superintendent, and estimator are direct cost of the job. They're not included in overhead. In response, they provided an affidavit of Mr. Hefner. In paragraph 24, that affidavit, he says it's overhead. We submit Mr. Hefner does not have any personal knowledge as to how Keiland classifies its worker. Are they part of overhead or are they part of direct cost of work? Thank you, Your Honors.
Thank you. We'll see you back on rebuttal in a few minutes.
Thank you, Your Honor.
Mr. Payne, welcome.
Your Honor, good afternoon.
Good afternoon. Take it away.
May it please the court. Weeks Marine has never denied that it owes Keiland money.
Can I pause you for a second?
Yes.
On the jurisdictional point that the court sent you the notice on, the question on. So in your notice of removal, you said Keiland had members, plural, but do you have any reason to resist or object to Mr. LeMieux's? They've got one member, and he's a citizen of Louisiana.
We had checked a website that gave us reason to think that there was more than one, but I defer
Okay.
to my opposing counsel.
All right, moving on. Sorry to interrupt.
No problem. Weeks has never denied that it owes Keiland money. The reason that we're here is the question is how much do they owe them? And the lower court correctly ruled that once this subcontract was terminated for convenience, it was converted to a cost reimbursable contract. So Clause 5 no longer was in operation. Clause 5 deals with progress payments that are made under a lump sum contract as the work proceeds. When a contract is terminated for convenience, that's really thrown out, and you now reimburse the contractor on a cost reimbursable basis, and it's an eminently fair system. If the contractor were paid, as Keiland contends here, on its own assertion of the percentage of completion of work that it had performed, it's very possible that it would reap a windfall if it turns out that that percentage is wrong, or if, in this case, the prime contractor disagrees. And that would be unfair to Weeks. But it would be similarly unfair to Keiland if they had been terminated for default at an early time when the project was delayed, perhaps through no fault of their own, and they were only able to complete, let's say, 20% of the work, but had spent 50% of the money. Certainly, it would be unfair to them to say, well, you're only going to be paid for the 20% of your subcontract work that you completed, even though you spent a lot more than that, because the conversion to a cost reimbursable contract says that the subcontractor will recover the costs that he has expended up to the time of the termination for default, plus in this case, 21% markup for overhead and profit. It's fair to both sides. Keiland wanted to insist that it should be paid a lot more. It submitted its first invoice for $256,000 approximately on March the 4th, but the termination for convenience came far less than 30 days later. It came just 14 days later. So there was no money due owing at the time, except for Weeks' willingness to immediately resolve this with Keiland and pay them on a cost reimbursable basis. And the record shows that there were many email exchanges between Weeks personnel and Keiland personnel saying, we need to see the costs that you incurred. And if they had been received by Weeks in an orderly manner, in a believable manner, they would have been promptly paid. Weeks had no motive to want to deny payment to Keiland, but the problem was Keiland didn't have the records. They didn't have certified payrolls for labor. They didn't have invoices to back up what they were asking for. In a couple of cases, they didn't pay their vendors, one about $87,000 and another one $11,000. Weeks decided we'll just pay those people directly. So Weeks paid $98,000 so they didn't have to worry about a payment bond claim from those people, and they didn't dispute that those vendors were entitled to that money. Then, out of frustration, when Weeks just couldn't get what it thought would be easy to get from a subcontractor, some evidence of the money that you've spent up to the date of the termination, they said, look, we're going to pay you $200,000. And it was clear by Mr. Hafner's deposition that included everything, including the $25,000 demobilization cost. Weeks felt that was more than enough to be fair to Keiland. Keiland got the $200,000, another $98,000 that it owed to its vendors had been paid, so Keiland had $98,000 in hand. The court below, I think, correctly determined that if there was an ambiguity in the termination for convenience clause in the contract, it was one that was created by Keiland because Keiland redrafted Weeks' standard termination for convenience clause to add the language that later became somewhat problematic. We think it wasn't ambiguous at all, but to the extent that it was ambiguous, the court correctly determined that ambiguity should be construed against the drafter.
What do you do with counsel opposite's argument based on the Louisiana statute that says owner pays contractor in whatever percentage, therefore contractor has to pay sub in the same percentage? I mean, doesn't that mesh well with the monthly invoicing and the progress payments or the percent complete?
It would, Your Honor, if there had not been a termination for convenience, but there are no longer any progress payments that are due. Once there's a termination for convenience, you have a cost reimbursable contract. There is no further progress. I would agree that if there had not been
But there was progress already. I mean, in other words, they billed for, a couple months of work or the first month of work, whatever it was, in March, and then Weeks turns around and says, well, sorry, we're going to terminate for convenience. It's advantageous to Weeks to do that, presumably. They would pay less or whatever. I mean, is there manipulation going on there?
No, Weeks certainly didn't look at it that way. Weeks realized that once they terminated for convenience, progress payments, past billings are sort of put to the side because now we're not going to pay you on a cost reimbursable basis. That $256 that they invoiced on March the 4th could very well have been more than that. They might have been able to show, well, we billed $256, but we really spent $300, and here are the invoices and the backup documents, and that's what you want us to pay us. But they refused to do it, and they couldn't do it. And that's why any statutes that's saying the prime contractor is to pay the subcontractor as he receives payment really doesn't apply in a situation where you've taken a lump sum firm fixed price contract and you've converted it to something totally different, a cost reimbursable contract. And I might add, Your Honor, that interpretation of the clause itself seems to be a case of first impression in Louisiana. But the lower court quite correctly did look for guidance, and it's in a footnote in a decision, for what does the federal government do? And there are just dozens and dozens of cases on the federal termination for convenience clause, and this is exactly the way it's applied. Matter of fact, that exact language appears in many cases. When there's a termination for convenience, the contract is converted from lump sum to a cost reimbursable contract.
Just to be straight, to make sure it's straight in my mind, Weeks paid Keiland $200,000. I'm talking about early on when basically documentation request, all those things had gone back and forth, not to Weeks's satisfaction. But so you paid Keiland $200,000, and then you paid $98,000 more directly to Keiland's vendors.
Yes.
And so if the original bill was $250-something thousand, you ended up paying almost $300,000. Wouldn't it have been better just to have acceded to Keiland's interpretation of the contract and then paid for demobilization?
Well, it was Weeks' position that the $200,000 included the demobilization charge. Weeks did not.
Well, yes, but if the demobilization was $25,000 or so dollars,
Yes.
and their original invoice was $250,000,
Yes.
why did Weeks pay $20,000 more, $25,000 more to vendors plus Weeks?
Well, Weeks paid the $98,000 in the vendors and then added $200,000 to it, not looking at it precisely the way Your Honor is now looking at it. Weeks decided, we can't tell how much more money we owe you. We're going to pay you $200,000 because we think that's more than enough. And Mr. Hafner, the vice president of Weeks, testified, and in our mind, that included everything, including this $25,000 that they wanted for demobilization. But Weeks did not agree that they were entitled to anywhere close to $25,000 for demobilization.
Well, but I guess I'm still just confused. You have a $250-something thousand monthly invoice, and if you'd have added $25,000 to it, you'd have been better off. And it doesn't seem, I don't see how Keiland could have possibly complained.
Looking back on it, Your Honor, that might have been a better way to handle it. But at the time, Weeks was just looking at, give us evidence of the costs that you expended, and those are the ones we're going to pay. And they weren't really making any comparison to the $256,000 progress payment request compared to what their ultimate costs might be that they were entitled to.
There was nobody at Weeks looking at this from a practical standpoint? I mean, or I guess Weeks was just so certain that their interpretation of the contract was correct?
They certainly were certain that their interpretation of the contract was correct because of the many years of experience in dealing with termination for convenience clauses. What was frustrating to Weeks was that they were not given the cost backup information that they were asking for in a rather prompt manner. Normally, it's been Weeks' experience that subcontractors can provide that kind of information. They can provide certified payrolls of labor. They can provide invoices from subcontractors. Equipment and materials are easily documented, and really was kind of mystifying why that information wasn't forthcoming. And that's what brought about all the hesitancy, because once Weeks realized that some of the vendors weren't actually being paid, and that's why they paid them directly, they became skeptical of the accounting practices of Keiland in general and whether they could rely on what they were asking for. And that just fostered an even greater demand or request for backup information, which, as I said, was never forthcoming. The appellant has argued that when we get into the issue of Mr. Hafner's testimony and what he said in his affidavit about whether or not certain costs were included, whether or not, for example, the foreman or the superintendent, the project manager should have been directed costed to the project or not, that his affidavit as to his opinions on those things was not notarized. And we've cited the law to the court that an affidavit doesn't have to be notarized as long as it is made and signed under penalty of perjury and verified as true and correct.
Can I ask you a question about attorney's fees?
Yes,
I think both sides below and the district court applied federal law on the recovery of attorney's fees. Is that correct?
well, we're having some difficulty deciding with the court below what law they applied, because instead of looking at attorney's fees,
Well, as you're standing there today, what law do you believe correctly applies? Louisiana law or federal law?
well, I think Louisiana law has adopted the lodestar analysis, which of course comes from federal law. And it basically applies 12 factors that a court,
Oh, but wait a minute, back to Judge Willett's question. We've got a Louisiana contract. It's before the federal court on diversity jurisdiction only. State law would apply in construing what that contract means, correct?
yes,
Wouldn't state law then also apply in computing attorney's fees?
I believe so, Your Honor. I think what I'm saying is I believe that the state law comports very well with the way the federal courts would look at it. And they would look at it applying the 12 factors in the lodestar analysis. And the way the lower court,
In Louisiana law, it permits recovery of attorney's fees in a breach of contract action, right?
yes,
And there's a specific provision in the contract addressing this, correct?
yes.
Okay.
Yeah, and of course, we don't agree that Weeks breached the contract. Weeks paid the money that it thought that Keiland was due and owing. Weeks did not impede Keiland's performance of this contract. They did not do anything to cause them to increase their expenses.
Do you agree that the district court concluded in its ruling that Weeks prevailed on the contract interpretation issue only at the bench trial and not with all the pretrial matters, correct?
Yes, that's correct, Your Honor. And
So then why would Weeks be entitled to attorney fees before the contract issue was bifurcated?
well, the court below found that Weeks was, you're correct, entitled to attorney's fees only after the bifurcation
Right.
took place. But Weeks was from the very beginning in a contest, in a dispute with Keiland as to what was the proper interpretation of the contract and whether or not whether it was a lump sum contract that was to be paid as Keiland alleged, or whether it was to be converted to a cost reimbursable contract.
Well, but I thought the district court even said at one point that neither of you were prevailing parties at summary judgment. In other words, the district court cabined this, and I don't see where Weeks challenged that.
Well, but Keiland has argued, and I believe the term that they use, that the keystone issue in this case was whether or not was the contract interpretation issue. Should this contract be considered to be a lump sum contract where we're entitled to be paid a percentage of completion at the time of termination, or is it a cost reimbursable
Well,
contract?
I think the district court would agree with you on that, but we're talking about prevailing party. You're only entitled to attorney's fees under the contract if you're a prevailing party.
Right.
And the district court said, well, Weeks, you're prevailing as far as the half-day, the bifurcated half-day trial on the meaning of the contract. But that's it, because you weren't a prevailing party prior to that and then after.
Yes.
So why did the district court abuse its discretion by saying you're entitled to attorney's fees for basically preparation and trying that issue?
Well, because the court did not look at all of the legal services that had to be applied to getting to that point. There was a tremendous amount of legal work that went into contesting the position that Keiland was taking. What the lower court ultimately did, and it's something that I think was somewhat unprecedented, they looked at, well, we'll look at how much money our decision allowed Weeks to save. They were asking for $705,000 approximately. We awarded them 300 and some. There was 380 or whatever that they did not get. So the amount of money that Weeks did not have to pay Keiland as a result of this decision, we will give you 20% of that.
Well, but the district court did that because didn't it find that it couldn't discern from what Weeks had submitted what fees were accumulated in preparation for the trial and in taking part in the trial versus the rest of the litigation?
It made that sort of a broad sweeping conclusion, Your Honor, but I don't think examined the evidence very closely. And the other thing that I would point out is that in other cases where the discretion of a lower court has been challenged on the percentage reduction that they've made to attorneys' fees, it's been 10 or 20%. And in cases where no backup was submitted, I mean, we had pages and pages of detailed billing entries that described the work that was to be done. But even in cases where there was very little presented to a court, the courts have said, okay, we're going to, by our discretion, reduce it by 10 or 20%. The lower court here reduced our legal fees by 65%. So they're not really giving full consideration to the breadth of work that was performed here.
What's your best case supporting the idea that what the district court did was an abuse of discretion?
What is the best case?
Yeah, what's your best case to support your idea that it's an abuse of discretion to do what the court did?
Just implying the lodestar analysis, I believe, and going through those factors, particularly the fact that Keiland exacerbated this litigation. I mean, let's face it, Your Honors, as federal court cases go, the amount in dispute here is comparatively small. There was an offer of judgment at one point of $100,000, which would have increased the $298 to $398. That was declined. So what's left and really is at bay here is a relatively small sum of money as these things go. Keiland was very tenacious, and it was every sense of the word, I think, a peculiar circumstance, which is one of the arguments that we made as to why the 20% prejudgment interest should not have been granted by the lower court. The peculiar circumstance is that you have a very, very tenacious appellant here who caused Weeks to spend an inordinate amount of money to defend against something which could have been easily resolvable, just providing business records to back up your costs. That's all that was necessary. And I see that my time is up, Your Honor.
Okay, Mr. Payne, thank you very much. Mr. LeMieux, I believe you've got 4 minutes on, well, 5? 4?
4.
4 minutes on rebuttal.
Thank you, Your Honor. Judge Wilson, to answer your question about the pay applications, there were 3 pay applications, not 1. So the pay applications totaled $580,000 as opposed to the 252. The 252
Okay.
was the first. So the value is there. Pay applications are monthly for work.
Wait, the March one was the first one,
Correct. And then there were 2 more
but the 2 more would have been presented after the termination for convenience.
for work that was done prior.
Okay.
So that's why. I mean, ultimately, they had 30 days to pay, but when they terminated for convenience, Keiland billed for the work that it had previously performed prior to termination. Another point, Your Honor, that you hit on was Louisiana Revised Statute 92784, which is imperative. It applies here. There's no question about it. So when Weeks stands up and say, look, all we wanted was the documentation, we wanted the documentation, we wanted the documentation. 2784 doesn't have a provision that says, look, this doesn't apply if you terminate for convenience. The reason the statute is there is for this exact scenario where a general contractor has enough information to bill their client for your work. The owner pays Weeks for our work, and then they turn around and they don't pay us. And the statute specifically says that they shall pay in proportion to the percentage of work completed prior to the issuance of their certificate of payment.
Well, wouldn't it be for the owner makes a partial payment, for example, or something, there are multiple subcontractors, and so you've got to prorate it out based on what the subcontractors have billed the contractor? I mean, in other words, wouldn't it be for the situation where an owner makes part payments and how to dole that out?
And that's exactly what happens here. The owner made partial payments for our work performed. But what that statute says and what it means is if you, general contractor, have been paid for a portion of work that a subcontractor did, you have an obligation to pay that sub for the same portion of work. You can't bill an owner, receive payment from the owner, and then hold that money and say, we need more information. That's a clear violation of 2784. Now, the questions were asked, what law applies to this? And clearly Louisiana law applies. And if we look at the prevailing party and we look at the Louisiana Supreme Court's decision in Stewart versus Nash in March of 2023, it specifically holds you cannot be the prevailing party if you yourself are in breach of the contract. That's what it says. And we sued them for breach of contract, and we recovered under a breach of contract, and there are still sums today that are due and owing. They still have not paid Judge Kane's decision holding that Keiland was entitled to sums under the agreement. The cases in Louisiana, like I've said, go back to 1911. This issue cannot be any clearer. You cannot recover fees. You cannot recover under a contract if you haven't paid what you owed under the contract. Ultimately, what we sued for was a recovery under the contract. At the time we filed suit, we didn't have a dollar. Through this litigation, we recovered $416,000. That is prevailing. And despite having those judgments, they still have not paid the sums due under the contract. There's no exception under 2784 that says we don't have to pay you or we can hold your money forever. They have to pay when due. And the district court specifically held that those sums are due. So if we look at Stewart versus Nash, and we look at Silverman, and we look at Murphy, and we look at all the other cases that we cited going back 100 years, because they, thank you.
Thank you. All right, we've heard helpful arguments from both sides, and the case is submitted. Thank you both.